You're listening to the Valley Current.
Mike, you look great in that picture. Welcome into the Valley Current. So you're looking pretty thin there. Have you been working out?
No, just eating less.
No, you just too
exercising
busy.
a little more.
Exercising
yeah, I lost
more?
30-something pounds though.
How much?
30. I'm 32 pounds down.
Wow, that's great. That's great. How do you feel? How do you feel?
All right. I'm not. I exercise a little bit, but I'm not in that much better shape than I was.
Well, you were doing this CrossFit stuff for a while, weren't you?
I did P90X and I got in good shape, but that was like 10 plus years ago.
Really? Okay.
Yeah. So and I do another beach body one. I do 4 weeks of the work. It's called.
Okay.
It's called 4 weeks of the prep. It's called 4 weeks of the prep, which you need to finish so you can do 6 weeks of the work.
Okay.
So we did the 4 weeks. Now we got to do the 6 weeks, but it's hard to find.
Are you doing it together with your wife, Julie?
Yep.
Nice. Well, I've been doing a lot of yoga, so I'll show you what that looks like. It's not easy.
Check you out, all flexible man.
I am. That's not hard. I mean, that's not easy stuff to do.
No.
And what you realize is that if you don't do it and you don't do it consistently, you really end up losing a lot of strength as you get older. You lose a lot of muscle, you lose a lot of strength, you lose a lot of everything.
Right.
I mean, you just can't be considered just a brain that's connected to a computer. I mean, you can't be thinking that way, even though I suppose it's a good segue into our topic that the Supreme Court finally issued its ruling yesterday in a case that you acted as amici in. Right. And I didn't see a citation to your brief, which kind of surprised me.
I was looking for it.
I was looking for it. I was really out there. I was hoping you got it.
The primary reason why is I wrote about the copyrightability question 1, and they dodged question 1.
I don't get that. I don't get why they did that.
Because I suspect that there was at least a split, just like in Lotus versus Borland, where at least 4 justices thought it was maybe copyrightable. Right. I mean, I wrote my brief, if you recall from our last podcast, because I was worried that judges would see this was copyrightable as a whole. Right. But also in the infringement analysis, you've got to filter it out, the functionality aspects. But they opted not to go in that direction. They instead said, well, maybe we'll just assume it's copyrightable and we'll instead get rid of it with fair use.
It seems as though the assumption most judges would take reading this is that it's enough information to be copyrightable, else they wouldn't even reach the fair use question, because in general, you could say they could have decided the first issue and punted on fair use, right?
That's right. I don't think we're going to see courts holding this uncopyrightable anytime soon, because they don't have to. They can just say it's fair use. They can just dodge the first question. It's a thorny theoretical question that doesn't actually have to be answered, which was actually the point I was making in my brief. So in that sense, I'm happy. You don't actually have to answer the copyrightability question to resolve this case.
Well, it's a case that I'm sure Oracle is pretty sore about, because they had a lot of money potentially riding on this.
Well, have you seen the press release they put out? It's like they were very sore.
Yeah, makes Google a lot bigger. Google's basically a larger monopolist now, and so on.
Yeah, basically. The court's just in bed with the monopolist, basically. So it was pretty vitriolic, I have to say.
Well, I'm sure that, this is the end of the road. There is no real reconsideration, rehearing, anything, right?
I don't think so.
Let's just make sure our viewers understand, our audience understands, this is a case that has been through a fair number of cycles in terms of litigation. And the Federal Circuit surprised people, I thought, at the time, when they issued that ruling in favor of Oracle. I think a lot of people were quite surprised the Federal Circuit had gone as far as it went in both deciding copyrightability as well as deciding no fair use.
The fair use one was the biggest surprise.
Right. And so when you think about it, maybe they did that intentionally to hope that this case would get to the U.S. Supreme Court, because it's like 1 in a million cases ever get a chance in the Supreme Court.
I don't think so.
No?
No, I think they just were lucky to draw a good panel of judges for them that believed that this was not a fair use.
The Oracle Federal Circuit level case ended up with the right panel of judges.
Right. I think you wind up with a different set of judges. You get a different answer.
Right.
Although, the Federal Circuit generally is pro-IP-ish. And so, the Federal Circuit is where you want to be on a copyright issue generally.
And so if you think about it, Oracle lucked out in the Federal Circuit, but Google was persistent. You got to give them an A+ for persistence. They didn't settle the case. They filed their petition. They did their oral argument. The oral argument is available on audio, on C-SPAN. In fact, I think you and I listened to it. I think we listened to it before we did the last podcast, did we?
We did. Well, not together, but yeah.
Right. And we were like, yeah, it was okay. I didn't think it was great. It
was not a great oral argument.
Right. I didn't think it was great. I don't think there was any great rhetoric per se used. And I don't remember this wording of creativity enhancing. What's the wording that's sort of this unique balancing test? Creativity reducing. I sent you the phrase that I quoted from the opinion. They seem to be suggesting that the courts have to look at balancing whether or not there's sort of a creativity retardation as a result of a finding that something is not a fair use when it does some sort of transformation on what is being used. And that to me was a concept that I had not seen in the U.S. Supreme Court cases. I don't know if you saw that, my grab of that quote.
Yeah, I tend to agree. Yeah, I mean, that's just not a normal thing. But the question is, how much is that dicta versus how much is it going to be? How much is it going to be for other fair use cases? I mean, the court seems to imply that this is really you're right. They say we're not overturning any other cases. We're not changing anything else. So I guess their view is this is what fair use involves.
Well, ultimately, it is a judgment call, right? I mean, it is a judgment call that looks at a bunch of factual factors, but then there's a judgment call that has to be made. And it is pretty much a human judgment call. It's not something that you could arguably put into AI and say, well, let's do the calculation on how many lines of code it is and what is the code doing and is it mostly functional or is it expressive? And then what are you doing with that code? Because in the abstract, most people do sort of say, well, it's not like just 2 or 3 lines. It's, thousands of lines, right? It's not a trivial number, but it's a trivial percentage because it's less than 0.5% of the body of what constitutes the entire Java corpus, right? If you want to talk about like a dictionary being a corpus, and dictionaries are still protected by copyright, but only as against maybe what might be called slavish copying, or put differently, there is a thin copyright here and an easier fair use argument when the thin copyright, very little is taken from the thin copyright because most of it is functional. Right. That's another way you could think about it. Like you can look at analogies like dictionaries and other compilations to some degree. And they're not doing necessarily work through a machine the way a language is. But I thought in many ways.
But the APIs are theoretically slavishly copied, right? I mean, they have to be.
Right, because a body of other sort of goodwill, if you want to really abstract it, that's not really owned by the copyright owner, like the goodwill
Right.
of the community.
That's really what it comes down to. And that was really what the court talked about in the fourth factor, right? That the question was, is the market substitution, is it because of how great your software is, or is it because of goodwill owned by, consumer surplus, if you will, owned by people who happen to have written code using these Java packages?
Right. It's a little bit along the lines of you are the author or now are the owner of a bunch of authorship that was so well adopted that it created this explosion of goodwill that is more owned by the public than it is by you. It's almost at that level. It's almost at the level of it's not all your employees that did all the applications that sit on top of all of these APIs. It's a bunch of other people that did that.
Right.
And so once you have a bunch of other people that did that, it's pretty much almost saying more of this should be viewed as open source. I mean, I don't want to sort of like confuse things, but there's almost an argument that all of these APIs should really have been viewed maybe by Sun, the original author, because Sun never took a harsh view on the use of these APIs. Sun sort of had an open approach to
they did treat it. Yeah, they did treat it more open. But really, I mean, the part that's interesting is it's really a computer language, right? I mean, it's like saying, well, you can make your own C compiler, but you can't use the printf command.
Right.
Right. But because the way Java is implemented, everything's in a package. And so they can say, well, it's not really the language. It's not really a command that's required to make the language work. It's like a side thing. And you can come up with your own side packages to do the same things. We came up with our language, but the language doesn't require all of these other packages we added. But the reality is everybody's like, well, that's not true, right? I mean, your base packages are the packages everybody used. Now, the question is, how far does that extend? Is that every package? Is it for all, is it for all, video processing packages? Is it for audio processing packages by third parties? And I guess Google would say, yeah, right. You write a package with commands. People should be able to use the same commands to do the same processes if implemented with their own code.
Right. I think it opens the door to a lot of companies beyond Google starting to think that, look, what before we might have worried would be copyright infringing, if we can take the same line of reasoning as is laid out in this opinion and say that there's just too many others that know how to use this, because I do think it suggests that in Lotus versus Borland, the command sequence becomes something that people are so familiar with that you should be able to use it to have compatibility right. In macros and everything right. else for the same exact reasons.
Well, that was what the concurrence in Lotus versus Borland said in the First Circuit, which got cited by Justice Breyer.
Right.
But I will say, I don't think I agree with you, except I don't think it will like suddenly cause companies to do this. I think they've already been doing it for decades. And this just affirms that they can continue doing it. But the reality is Oracle was the one who wanted to change the status quo.
Oh, you think more of the world was of the level of, come on, we really can't challenge that. The cost of litigation is too high.
I mean, anybody who uses Wi-Fi or, anybody who used a Hayes compatible modem back in the day, right? I mean, the brief, I didn't get cited, but the briefs that did get cited are the briefs that all explained all the different people who'd made different compatible API uses over the years. And that was persuasive to the court. I mean, Oracle's even doing it now. They've got their own API that's compatible with Amazon Web Services, so that they can woo customers who've written scripts that work with AWS. Now they can work with Oracle. So To me, Oracle's statement about how this is all just about a monopolist getting rid of competition is shocking, considering that they're doing the exact same thing in order to spur competition with Amazon.
Yeah, I mean, I'm betting they had all of that PR worked up to be anticipating an adverse outcome, right?
Well, I don't know. The statement is so awful. It makes it. I feel like it didn't go through communication channels.
So you think they just did it on the
I don't know.
moment?
No, they're smarter than that. I'm sure they had PR companies, but it just makes me wonder, right? They're talking about how this kills competition. It's all about monopolization, when in fact they're the ones who want a monopoly on Java.
Yeah, right.
Right? I mean, that's really what it comes down to. Their view is nobody else can make a Java compiler.
Well,
they're the only ones.
At some level, you could say the Java language might die as a result of it being locked into a particular company that is either feeding it or starving it. And that's kind of the whole theory of open source, which is if something is treated more like open source, more people will add to it, more people will debug it, more people will improve on it, right?
Or they can re-implement it themselves.
Right. I mean, it's an interesting question, which is where will this take the Java language? Is this a signal in a direction of opening it up?
I don't think so. I mean, Kotlin is already replacing Java as the language of choice on Android. And I don't know if Google was doing that in part because they saw an injunction potentially coming and big damages, or if they're doing it in part because Kotlin's a better language. They're plug and play. But now that Android is established, right, and Oracle would say, well, it's only established because we're free writing off our API, of our intellectual property, but we'll put that aside for a second. Now that it is established, they're like, we don't actually need Java, which is actually not as good as Kotlin. My kids' robotics team, they can use Kotlin, and it definitely has some advantages over Java. It has some disadvantages as well, and that not everybody uses it, and it's a little harder to learn. But once you learn it, it's got some definite shortcuts.
So do you see it as this is a kick in or shot in the arm for Google to just invest even more on what might be called transforming existing programming APIs? Not at all.
No. No, my view is that it's business as usual.
Oh, nothing. This doesn't really change anything.
No, this is status quo. It will lift the pall. So they probably had plans to do some, and now so now they'll reuse an API instead of develop their own. So it'll free them to do it on a technical basis, what they think is best, or on a marketing basis. But I don't think this is going to create some avalanche of API usage that wasn't there before.
But it will create more lawyers asserting fair use as a sort of non-Rule 11 violation, not an absurd
for what?
For commercial infringements, what might be called. I mean, let's look at the 4 factors, and then we'll wrap up quickly because I know you have very little time.
But there are so few cases where this is actually raised. There is a case pending, I blogged about it, in Western District of Pennsylvania, where somebody made a plug-compatible fireworks controller. And, they copied the control codes, and the court said that was infringement. I think that case goes away.
It gets reversed on fair use, right?
Right.
For the same reasons.
Right. That case makes the news because it's so rare. Because ordinarily you make plug compatible stuff all the time and nobody stops it because it's stupid to try and do so. It was only because Oracle had big lawyers behind them and got a good panel at the Federal Circuit that they got this far. Look, the Supreme Court was 6-2. It wasn't even a close case.
Yeah. I mean, I guess at the end of the day, 6-2 these days
might have been 6-3 with Justice Ginsburg.
Right. I think it would have been 6-3.
But she might have gone fair use too.
Yeah. I mean, at some level, I think the equities, if you look at the 4 factors, to me, most of the factors end up cutting in favor of Oracle from a sort of strict analysis point of view, because it's a commercial setting. There's an actual volume of code. It's not just a few lines, not just a few notes. It's not just a few seconds of video. It's not just a few anything.
That's where the Federal Circuit landed.
Right.
And the one thing I would add where I disagree with the court a little bit is on transformativeness, because the reality is they use these APIs exactly how they were intended to be used, right?
Right.
So yes, they were using it for Android, which was a different system. I think where Google wins is they had a jury verdict, which said a jury could have found that it was transformative, and we will live with that factual finding.
Right. The jury can kind of make black be gray or gray be white, depending on how they view the particular parties.
And I think that will then be read in the future as it's transformative.
Mm-hmm.
But the reality is it wasn't that transformative. They were using the APIs exactly as intended.
Right. Well, the transformation is in what they produce to the market, right? The bigger product.
They use them to create a different back end that was transformative.
Right. And so you could say somewhere in the story that a copyright owner whose product becomes too successful, with a lot of third parties sort of lending their hand to success, does open the door to others being able to leverage some of that success.
I think that's right.
Right. So you can't just say, well, I own all the goodwill associated with this, and you have to come to me for a big, expensive license, when in fact it was the success that was sort of almost based on the open nature of it that got the whole thing started. There's sort of a certain sort of poetic justice in that, because it was open to begin with. And in many ways, Sun would have never brought this case that Oracle brought. And by the way, I too think that at the time Larry Ellison decided to acquire Sun, part of the reasoning, the sort of M&A calculation, was based on the view, I'm speculating here, but I think it's pretty obvious that at the time he was getting a lot of interesting assets from Sun, plus the potential of this type of lawsuit, because it probably would have been worth, sort of on a pro forma licensing calculation, an 8-figure number, or maybe even a lot more than that, maybe even a 9-figure number.
Well, they asked for $8 billion.
Right. It wasn't a trivial amount, and it would have paid for that entire M&A deal, because I don't think that whole Sun acquisition was done for a 10-figure number. I think it was done for a pretty substantial 9-figure number, but so then we're getting a lot of other assets as well. So it's an interesting story. But if you look at, you don't think, see, this is where you and I may differ. You don't think it's going to have some huge reverberating effect in the copyright bar or the way copyright litigants look at things, right?
Maybe a little bit, and like the Andy Warhol case that just came down might come out differently. Because
which one are we talking about? Which one is that?
Well, this is the use of the Prince photograph, where the court said it wasn't really transformative because, he just added some color.
Right.
And it was commercial because, it wasn't just artistic.
Right.
And there's some language in this that might help Warhol on that, it's a different thing because it's arty, and there's language about art in the opinion in that sense. So there it might have an effect. It's a rule of law with factual undertones, right? The mixed review may wind up having a reverberating effect. I don't think it's going to have a big effect on the API market.
Yeah,
on the way we view APIs. I think I think there'll still be a debate about whether they should be copyrightable. I think people in practice will continue to do them because most people knew you could do them, and will allow it to continue. And it'll be the fringe cases that'll go away.
So you're actually categorizing this as pretty much limited to APIs. And no. View, right?
No. I don't think so. I think there's language in here which will have broader effect. How much broader, I don't know, because it reaffirms Campbell versus Acuffero's music on transformativeness. So there is some language here on transformativeness, on the definition of the market, that will have a downstream effect in how we look at the four factors.
Right.
And copyright scholars and practitioners will grapple with those things for years to come, and there will be cases.
Right.
Would it be a large reverberating effect? I don't think so. I think it's going to be on the margins.
Because I'm going to give you a provocative statement and you can criticize it. I actually look at this case to some degree as the court saying, look, ultimately, we have to balance what we're now calling creativity-related harms and whether those are either outweighed by or they outweigh the needed incentives for authors to create. And if we conclude, even in the face of all factors going the wrong way, that is going in favor of the copyright owner, that there are creativity-related harms, that is, the community is not able to take advantage of something that has so much community wealth in it, so much what we're calling in the abstract goodwill that's not owned by the copyright owner. It's not locked up in the copyright. It's not locked up in any trademark. It's not locked up in any IP. It exists in the fact that the community has become familiar with using things this way. Then there are creativity-related harms that trump everything. It's like a trumping factor. It's like I'm the seventh juror. I can wipe out what the six jurors say.
That is an aggressive reading of the case.
Yes.
I have colleagues who would love that reading.
Yeah.
I wonder whether it will turn out that way in practice.
Well, that's what I'm saying opens the door.
Because it opens the door, but even then, even here, the court went through the four factors, right?
Well, they go through it because they kind of feel like they have some obligation to the
reality. Well, that's true. The reality
that.
is the courts decide whether it's a fair use, and then they go through the factors.
Right. Yeah,
so that's what happened here.
There always is like a gut reaction. They did what? When? How?
And so we read cases like one I read was the Dorsey Kinderling, the Grateful Dead case, where it was Grateful Dead posters that were copied identically, but down to a smaller size in a coffee table book.
Right.
And it's arguably a fair use, right? So because it's a different purpose, it's like for preserving the history. It's in a book. It's not advertising in a poster, et cetera, et cetera.
Right.
But the lengths the court goes about how transformative it is because it's a thumbnail now and not a big poster is like ridiculous. Because it's not. It's like it's the same thing. It's just smaller.
Right.
And it just happens to be a fair use. So your point is that this court gives credence to that.
Yes.
If it's a fair, so I think that always went on. So I think it will still go on, and this case will be cited a little more. The problem is you can't do it explicitly, and so whether this opens the floodgates or not will depend on how explicitly you think this case will allow it. And the problem is this case says we're not overturning the prior precedent. And
I don't understand how they could even realistically say that, except to say we think then it should have a more narrow interpretation to just software or just APIs or just the particular facts. But the Supreme Court doesn't sit as a case of fixing error. It sits as a case of sort of extending policy.
Yeah, I'm with you on that.
Right. So, and policy here is what is the meaning of the fair use statutory principle, which is, you could argue a derivative of the First Amendment, some additional freedom that others have to take advantage of expression, if that's what this is, given that we didn't get a ruling on the first point. But let me make another big provocative statement. All the cases that are pending where various websites have used photographs of various photographers that might well be properly marked as copyright owned by the photographer, properly registered, properly everything. I think that those websites that are mashing up and morphing up those photographs in ways that produce something new and different for whatever purpose, those photographers may lose on this creativity test.
I don't know about that.
No?
No, well, there are two reasons. Number one, the photos aren't functional in the way that the APIs are, and that goes throughout the opinion.
Right.
Number two, these photographers are in the business of selling photo rights to these websites who are then refusing to pay for them and making money by republishing them. So I think that commercial use and the market substitution is a big enough. So if you had a true mashup, like a real, like a girl talk type music mashup with like a million different photos, then you'd say it's transformative. But it's like, here's a picture and I'm going to make some snarky commentary about it.
Right.
I think those still lose.
No. So is there any category other than APIs that you would say?
I think the artistic use, like I said, I think anywhere where there's a whiff of functionality. So, whether this leads to aesthetic functionality, where pictures wind up being used for, functional purposes or designs, so in the structural, like in the Star Athletica case, with the design of clothes and whatever, that might have some fair use with the functional aspects.
Oh, they might go back on that case then. They might look.
No, they'll say it's copyrightable.
Yeah.
But you have to look at fair use. You got to look at why you did it. And
it's more like an antitrust analysis. It's more like an antitrust analysis that goes on in the fair use, where you look at the market and substitution and so on.
You got to look at the context,
right? And so do you say to yourself, there's some intellectual property businesses that would start to worry somewhere? Because I could see, for example, a spillover on this applying in trade dress cases where there's a close question of, well, are you impacting the creativity harms? Are you causing a creativity harm in letting someone assert trade dress in an area that somehow is leveraged by the popularity of the way in which people interpret trade dress? Like, I would think we could.
That's already that. Well, yeah. Although that's a different. I mean, it's designed to protect goodwill,
right?
So, and it can't be functional. So, if it's functional, then maybe. But yeah, you could have some, right? If you're claiming trade dress in the look and feel of your software, absolutely.
So let's go back to why they didn't likely take the question of copyrightability, because it seems as though they could have said, yes, this is protected by copyright. Why leave that open? Why?
I think they could. My view is it was split 4-4.
4-4 on copyrightability?
Or majority against.
Really? And
But if it was a majority against, they would have had a ruling. So I think it was split 4-4.
So
just like Lotus versus Borland.
Really? So I didn't come to that conclusion. I came to the conclusion that this whole area is one that they don't really fully understand and they don't see as very understandable. And they were leaving the Federal Circuit with what it ruled. Right?
Breyer wrote a very nice, detailed opinion about how APIs work. He had the appendix. I don't think it's because they didn't understand what was going on.
Okay. So they got what was going on, and they just said...
What they said was, they might have said, we don't know. They might have said, what are we supposed to do here? And they might have read all the briefing and said, look, there was creativity in how you wrote it, but we don't know what to do with this merger doctrine thing. We don't, this isn't exactly Baker versus Selden.
Right.
So they might have honestly said, we don't know.
But do you see what it does? Interestingly enough, it opens the door to judges who don't want to deal with tough infringement cases or tough copyrightability cases.
Yeah, we're not going to get copyrightability rulings.
Just go right to fair use.
That's what's going to happen.
Just go right to fair use, and if you can find it, or you can establish that there's creativity related harms,
you preserve it for appeal. You have one paragraph that says this is not copyrightable. Cite a couple cases. Cite an article. Even if it is, see, Google versus Oracle. Here's the fair use analysis.
Okay, so now let's end on one note, which is we've talked for a long time about when are they going to re-enter the Alice fray on what is and what isn't patentable. They didn't decide copyrightability expressly. You think because it would have been a 4-4 split that they understood it. Alice issues and whether or not something is or is not patentable based on Section 101 is still out there, still playing its role in the district courts and still resulting in federal circuit appeals, some of which get, summary treatment, some of which get written rulings. Do you see this having any impact on where they land when they eventually get the next version of the Alice 101 issue? Or is that like, no, this doesn't touch that at all?
No, because the next 101 ruling, knock on wood, will be the American Axle case, which is where they called like a steering shaft an abstract idea.
Right.
So I don't think that has a little to do with this.
So you think they took that case? Did they actually take it?
They did not take it.
They didn't take the case. But
It's still pending.
Oh, it's still pending. I thought they rejected it. I thought they
I don't think they rejected it, have they?
Okay, I thought I saw that they didn't take it.
That's
what I thought. And so I thought that was the right case they probably should have taken and probably should have said, hey, Alice doesn't go this far, but maybe you'll tell me, no, it's still pending. I thought I saw that it had been declined.
Oh, I had not heard that.
Because it certainly hasn't been argued, right?
No, it's not been argued.
That would have been a case that we would have definitely wanted to.
No, it's a pending petition.
It's still pending. Okay, good. So you're saying, well, if they take that case, there's nothing in this case that's going to necessarily change any of their views. But if you take this view about what is and what is not creativity.
And by the way, the court asked for a response to the petition.
Oh, is that right? So you think they're sort of close to decide?
Yeah. Well, the brief was filed last week.
Okay.
The response brief.
Okay. So in general, you don't see any overlap. Like I think of the Supreme Court.
There's some overlap, right? Because Breyer doesn't want to protect stuff that's functional in a particular way. Right. So here you have the author of Mayo, and you have who's also authoring this. So it makes you wonder how you can get any kind of protection for computer software.
So you would say,
but that's not going to be the next case. The next case is not going to be about computer software.
Right. Your point is what's going on here is the next case is going to have enough hardware in it that it's going to be easy for him or somebody. I don't know if he's the designated writer in this field. You're pointing out that he's decided a lot of these cases, right?
The next case will be the modern day Diamond versus Deere, right? Dialing back, setting an outer limit on what can be unpatentable.
Okay.
That's my guess.
Which will be good. Which will be good for the software industry or bad for the software industry? Because there definitely are some people that would say
it'll be good for some aspects of the software industry, but the software industry, it's hard to get a patent these days. There are people who do it.
I mean, there are these days where if you're taking a very strict view of what the Supreme Court has done to software, on the whole, it has not been that supportive of broad IP protection for software, whether by patent, by copyright, by anything. Maybe trade secret will be the next place they make a ruling, because we've got the Defend Trade Secrets Act that's now a federal act, and I don't think they've made a ruling on that yet that speaks to software. But this ruling is not necessarily that, hey, the software owner should feel happy with their investment. Whatever they paid for this, they didn't get the return that they expected to get. They probably regret not taking whatever was the last settlement offer that Google made. It might have been a 10-figure number, but not as big of a 10-figure number.
Well, this case is an ironic one because I usually fall very pro protection of software, and yet I thought Google clearly should have won this case.
Right.
So
you and I differed a little bit. Yeah, I thought the unfortunate part was that Oracle was the owner. If it had been sort of, a smaller company and a bigger company, it's two big companies, so you really can't have a lot of pity on Oracle. Shouldn't have mattered, right? Shouldn't have mattered. So any final remarks about this, Mike? There was a lot of briefing. I thought you did the best brief of all of them, frankly.
Well, thank you.
I was waiting to see. I was waiting to see a footnote that gave you a little bit of credit.
I would love that.
creativity because you definitely had a creative approach to it.
I did. I did it because I felt like nobody else was saying what needed to be said. But obviously, all the other people had the right idea because the court didn't hear what I had to say.
I mean, they did
a little bit. They actually wound up doing what I suggested doing, which is even if you find it copyrightable, this should be allowed. And that's essentially what they ruled.
Right,
so,
right. But if you look at all the briefing, like put a different way, if you were to put into one ginormous box all briefs that were filed by all parties, all amici, everyone, it would be thousands and thousands of pages. And I have to say, most of it would not have been covered by this opinion. Most of it was probably, more of it was probably dealing with the copyrightability issue. And they just decided to say, hey, we're the Supreme Court. We can decide what we're going to decide, when we're going to decide it, and we're not going to decide this now. And that's the virtue of full tenure on the Supreme Court. You get to do that. And I don't think
that's how they roll.
Right. That's how it goes. And I don't think that Justice Barrett, was that Amy Cohen Barrett, right?
Yeah.
Is that right? I don't think she would have changed anything here, right?
Nope. She could have voted either way. It would have been the same outcome.
Right. And it's sort of the end of the road for Oracle on this, and perhaps it might be the end of the road of how they think about bringing litigation, because the interesting question folks asked is, if this went the wrong way against Google, what might Oracle have done in their own enforcement activities in the future in a much more aggressive way, because they are one of the more aggressive enforcers of license breaches and other intellectual property violations. They do, police customers that, quote, take advantage of them. So even customers are potentially targets. But interestingly, this might have cooled the jets. Last question, does Google have any right to get attorney's fees in the district court as the prevailing party now in a copyright case? Because they're a prevailing defendant, and those legal fees are not trivial, right?
Maybe.
Think about that, right? That's the part of the Copyright Act that a lot of people don't appreciate. The prevailing party ultimately does get, particularly if it's a plaintiff that's registered in advance of the infringement, but all defendants, I think, get, regardless, prevailing party if they're the prevailing party in legal fees. That could be a pretty stiff bill by the time all things are done here, right?
Yeah.
I mean, that advertising might actually, that advertising might have shot Oracle in the foot in terms of how Google feels about pursuing those legal fees, right?
Right.
And the district judge would probably be like, you take your risk, you're a big company, you pay the price for losing. That's just the way it goes.
Right.
Well, that might be the next round here. Maybe that case eventually makes its way up as well. Seems like there's got to be some ruling on that too. It's clearly a contested case.
I mean, considering Google won at the district court twice, it's hard for it to say that it wasn't a clear victor, right?
Right. Interesting. Well, thanks for your time, Michael. Professor Michael Risch, you're doing great work in Villanova. We're very proud of you. We're proud that you're staying on top of all these developments as quickly as we are. And you've done a great job for us. So thanks very much. We'll look forward to doing it again on the next case.
All right. Thank you.
You take care. Give my regards. Bye-bye.
Right, bye-bye.
Tune in next time on The Valley Current.